adjournment আছে ইয়াতে দি দিয়ক লিখি।
I beg to mention item number adjournment delayed. Wrongly listed by the
Item 1 for withdrawal.
yes.
The order actually
Party
applied to
adjournment.
Malia.
You want to withdraw it?
Listing খিনি মই
Malia, the order has partially complied it. I have to challenge it.
item number on কৰাটো চাওক।
Oh, let's on.
ৰ'ব মই লৈ আছো দাদা এতিয়া নিদিব। Item 2 for motion মই লৈ আছো।
What is this motion of 2019?
Matter.
Well, I pray as to why it be should declaring inaction otherwise to the point of it. So you are TET qualified.
Yes.
Why you should be appointed?
He was he had more he could more mark he had appointed some lower mark.
No, appointment is not on the basis of TET mark. TET mark is one of the requirements. Have you made out a case that TET mark qualification, your otherwise those basic qualification requirements all added together, you are more and somebody else? Make him a private respondent. Make him a private respondent. Challenge his appointment that he is a man lower than me.
Well, they have not met the party but they had annexed this
But we can't entertain in this manner.
That's why the petitioner what happened when I talked to petitioner he wants to engage some other lawyer so he
Sorry, we after 4 years we won't allow that. We are dismissing it.
Only 1 week time.
Sorry.
So that petitioner can whatever he
On the last occasion, we gave you time, 13/10/2020.
one more. He
sorry.
wants to engage some other lawyer.
Let him engage, file a new petition. We are giving him liberty.
Otherwise, one week,
Heard Mr. S. Hawk, Land Council for the petition also. Mr. Hawk, Land Council, after the order dated 13/10/2023, states that the petitioner intends to engage another counsel, and therefore the matter be adjourned. In our order of 13/10/2023, we had noted that the petitioner makes a claim for appointment as a teacher on the ground that his TET qualification mark is more than others who had been appointed. Full stop. Appointment as a teacher depends upon the TET qualification marks along with the marks that may have been secured in the other qualifying examinations. Even if it is so, there is a requirement under the law that if any candidate below the petitioner on merit had been appointed, the appointment of such candidates are required to be assailed, and it cannot be a petition that because of any alleged illegality, it is the petitioner is entitled to a direction for being appointed. From such point of view, the aforesaid question raised earlier by the court had not been answered by the petitioner, and now the petitioner seeks for an adjournment by stating that he intends to change the lawyer. We are unable to accept the said contention. Writ petition closed. However, petitioner given liberty to approach again if so advised and if permissible under the law.
Item 3.
It's a petition of 19 question. Petition 19 where notice is yet to be issued. Yes, Mr. Khan.
Provincial has not survey.
Provincialization of service.
But the District Committee Lordship has not considered.
Sorry, please repeat once again. District had recommended. State
has not recommended.
Yes, Mr. Kaushik.
We have filed a
Consider and pass your order.
yes, Lordship, we have filed appeal.
appeal.
Not appeal. What is the procedure? DLC will recommend.
This DLC recommend.
No. And under the law, what is the procedure? DLC will recommend. Then it will go to the SLC on its own, or somebody has to file appeal.
No, once the DLC recommends it to the SLC, SLC will consider the recommendation of the DLC.
And they pass it order.
Yeah.
And-
And if SLC finds that they are entitled, they will recommend it to the government for approval.
Approval. And if they don't find, they'll reject.
There is. And
Against that, there will be appeal under
Section
section 14.
appeal type.
So here is a case, DLC recommended, SLC has not done anything. Where is the recommendation of DLC?
মানে DHC recommendation page loss 58, 52.
Page number
Page 52. I have
52.
filed for additional affidavit.
Heard Mr. M. Khan, Land Counsel for the petitioner, also heard Mr. B. Kaushik, Land Counsel for the respondents in the secondary education department. As well as Mr. Girin Pegu
Deputy
for the Deputy Commissioner Karimganj. Seba, anybody appearing? None appears for the respondent number 6 being the authorities under the Board of Secondary Education Assam. For the purpose of provincialization of how many petitioners?
My lord petitioners 11.
11. The petitioners herein are all teachers of
Indira Memorial.
Indira Memorial Girls High School at Mobarakpur in the Karimganj district, and claims that all of them had been recommended under the Provincialization Act of 2017 for provincialization by the concerned district scrutiny committee. The limited grievance raised is that in spite of being so recommended, and as required under the rules, the recommendation by DLC had not been given its due consideration by the SLC. In view of the limited grievance, we disposed of the writ petition directing the SLC. Who is the head of the SLC?
Scrutiny committee, not.
They have filed one appeal in
This
page
state level
40
scrutiny,
page
sorry.
44 is their appeal, which they have filed before the government, because
Appeal, why should they file? Appeal is only when SLC will reject.
their contention is that SLC has rejected.
Where is the rejection by the SLC?
My lord, that rejection is not there.
Just a minute. The SLC is headed by?
SLC is headed by the Director of Elementary.
Headed by the Director of Secondary Education Assam to give a consideration to the recommendation by the District Scrutiny Committee available at page
52.
52, annexure 1 to the additional affidavit, and pass a reasoned order thereon. By requiring the state level scrutiny committee to pass a reasoned order, we are clarifying that we do not they do not mean that it's a direction to the state level committee to approve the recommendation, but on the other hand, the requirement is for the state level scrutiny committee to give a due consideration and pass a reasoned order thereon. Full stop. Although an appeal had been filed by the petitioner under 14 of the Act of 2017, but we are of the view that said appeal would be premature, as an appeal would be maintainable only after a rejection by the state level committee.
Against the decision of DSC.
In the event the decision of the state level scrutiny committee is against the petitioner, liberty would remain with the petitioners to file appropriate appeal under section 14 if so advised. The requirement, please don't go interrupting, Mr. Khan. I'll adjourn the matter straight away. Any interference while the order is dictated, result is it will be adjourned for the day. You don't have to
Detailed representation before the.
adjourn to be listed again. Yes, next item.
Item 4.
Sorry, Lord, I'm withdrawing my.
Try your luck next on the next day. Yes,
My lord,
next item, please. Item 3.
Item 4.
my lord, I'm extremely sorry, Lord.
Does your sorry will help me? And when it's a simple request to every learned counselor, please don't interrupt when the order is dictated. All corrections will be done at the end of the order. Why can't you respect our request? What do you gain by doing all this? Can't you have a patience of 1 or 2 minutes? We are definitely going to hear you whatever you want to say. Because it disturbs the flow of the order, it disturbs the secretary, and ultimately everything is gone out of the mind now. So we have to hear you again, therefore adjourned. It's already out of the mind by now, whatever I intended to say. And every day the same thing, Mr. Khan, you have this problem. Earlier also it happened with you. You are so enthusiastic.
I'm extremely sorry.
I know you are sorry, but you repeat it every day. That's the difficulty.
It will not be.
The decision to be taken will be done within a period of 3 months from date of receipt of certificate copy of the order. Yes.
Item 4.
Lord, it's regarding my lord, non-declaration of the result, my lord. I have appeared
Non-declaration result by Guwahati
yes,
University.
yes, but in my lord. The university to produce the report why the
Mhm.
in the earlier order, my lord, has been specified. My instruction is that admit card has not been issued. My lord, the form, it should be approved by the principal of Kesda Smart College, persona number 4. My lord, without my lord that approved help, my lord, admit card could not be issued. And without admit card, he appeared. Page 31.
He appeared in the examination without admit card.
Without admit card. Page 31. Down below, handwritten, my lord. Page 31. 32, 33, 34, 35. Same situation.
31 page number.
Page number 31.
He is
Down below.
Orijit Sarkar or what? Orijit
Yes,
Sarkar.
Lord.
Name on the examination center, Guwahati.
So there may be some attendance, my lord, aspect, my lord. So, my lord, that should be approved by the principal. Then, my lord, admit card is issued by the university. So the college will be in a better position to verify the. My lord, actually we have submitted the original, my lord, the form to the college, my lord. The college has not scrutinized and they have not, my lord, forwarded to the university. But after the admit card was not up to date in the my lord, in the site, my lord, website, my lord, I have approached the college. And college authority, since we have already submitted all the formalities because we have already paid the fees also, my lord. They have allowed to, my lord, sit in the exam.
No, college
Hello.
cannot allow you. It is the examination conducted by the university, not by the college.
Yes, my lord. But the
College is only a facilitating entity in between.
yes, my lord. But my lord, since we have submitted the examination fees
So-
and
So you ask your college then why they
yes,
have
college,
not
my
done.
lord, we have already approved, my lord. The college, my lord, told that you have not submitted the original form. That means the
So it's a
physical form.
dispute between the petitioner and the college, not the university.
Yes, my lord.
University within their own regulations, they are right.
Because this is the online submission, my lord. I have submitted all the.
So you may have done. So your remedy is against the college now.
Because we have made the college also as a party in this case, my lord.
So we issue notice to the college. What else to do?
Yes, my lord. But
I understand your difficulty.
yes, my lord. But since my lord, the
College is under your department, I think. Why the college is behaving in this manner? He says that I have given the complete application form, etc. But college is not forwarded it to the university. Who appears for the college?
college, my lord,
Hmm? Which college?
KC Das Commerce College.
Heard Mr. D. Gogoi, Learned Counsel Petitioner, also heard Mr. P. J. Phukan, Learned Counsel for the Guwahati University, and Mr. Tawildar for the respondents in the Higher Education Department, Government of Assam. This writ petition is instituted for a direction to the respondents in the Guwahati University to declare the results of the third semester BBA examination, which the petitioner appeared under roll number UM-211-020-0061 for the 2022-2023 session. As it is a matter where the results had not been declared by the Guwahati University, we required the respondents in the Guwahati University to inform the court as to why the results had not been declared. Mr. P.J. Phukan learned counsel for the respondents in the Guwahati University by referring to the attendance sheet maintained by the Guwahati University in respect of this center, examination center, K.C. Das Commerce College, had stated that the results are not been declared as because no admit card was issued to the petitioner to appear in the said examination. Mr. D. Gogoi, learned counsel for the petitioner, on the other hand, states that the petitioner had submitted all the necessary documents and the filled up application form for issuance of admit card to the college authorities, but the college authorities had not forwarded such documents to the Guwahati University to enable them to issue the admit card. Upon the college authorities being approached, what do they say, Mr. Gogoi?
My lord, they told that you have not submitted.
States that the petitioner had not submitted the application form. In view of such submission by the college authorities, the principal of K.C. Das Commerce College to remain personally present before the court on so-and-so to explain the situation with the complete records of all the application forms that were submitted by all the candidates for the BBA 2022-2023 examination. This form. The requirement of the principal to appear shall be communicated by the learned standing counsel for the higher education department through the director of higher education. Nick. Thursday. Ask him to come with the complete record of all the applications forms submitted by all the candidates.
Copy of the order
A copy of the order be made available, Mr.
regarding
Yadav.
third semester.
Third, sorry.
Are you hearing?
It's identical to the one that you are working with on the order.
Mhm.
Only on 13/10/23 minute in last set of cases minute. Only difference is madam that
Difference with the earlier matter.
no, it is identical, same minute.
Identical with which matter?
Only minute
Identical with which item? Mr. Jha? Oh, the Belik order.
Order has- yes. Only in this case, my lord, appointment has not been made by the government.
Against the post where the petitioner was
My-
working.
my lord.
Okay, Hari Marilio. All everything same.
Other same.
Will paragraph 5 be also same? Paragraph 5 of the earlier order, will it be same or we have to rewrite the facts?
I think names and particulars will be different. Colleges and,
No, advertisement dated same.
no, those will be different. My lord. Advertisements and appointments approval by the government, by the college authorities, that will be different, my lord. Otherwise, all are same. So I will,
And then let us hear you. I think we'll have to write something.
my lord. Petitioner has been working as a Bodo language teacher.
In Purvanchand College,
My lord,
Boro language.
on being appointed by the college below authorities. The advertisement for the same post was made on 26/16 at an nectar A below, and by
20,
resolution of the governing body
20 advertisement is
26
26
2016,
advertisement.
my lord.
By your appointment advertisement or the new advertisement?
No, appointment advertisement. My appointment advertisement.
Okay. 26,
And the
16. And against which
resolution number
advertisement he
25/7/16
participated? Against which advertisement he now participated in this election? In the earlier case,
earlier case.
there was an advertisement on 28/12/2022. In this case, which advertisement?
Oh,
24.
This is dated 8 November 2022.
yes, my lord. Page 24, my lord. Present advertisement.
The present advertisement.
Yes, my lord.
Earlier advertisement was walking interview,
My lord.
16 walk-in,
My lord.
but the post was not sanctioned.
Post was not seconded there.
Now the post is sanctioned,
Post
they
is
issued an
sanctioned.
advertisement.
Yes.
Earlier issued by the principal college.
Now
With the permission of the,
also principal?
Now
Yes.
by the principal again,
with the.
with the permission of the government also.
No. Earlier selection, if you followed the rules, and plus it is a selection, why that will be ignored?
The permission from the DHC because in the advertisement it says 24.
Understand? But these are some kind of irregularity. It's not an illegality.
See, earlier when college was advertised, the position, the particular department was not sanctioned by the government.
That don't it.
There is no
No,
approval. for
that
the-
may not have been. We understand that.
That was not.
From your point of view, I understand.
Sure.
But rightly or wrongly, you have induced one man through a selection process to work in that college because there was a requirement. He works for now almost, one worked for 10 years, other worked for 7, 8 years. After 8 years, you wake up and decide that post must be sanctioned and there must be approval. What will happen to that man?
That part,
I mean, you just can't throw him away.
Lordship,
When you need him, you bring him in,
it is the
make him
internal-
work. 10 years of his career has gone by. Now now you say that now I have sanction, it will be a new advertisement, you please go.
That is not the issue. Lordship.
This is
Lordship,
apparently so. We'll decide this matter.
earlier, Lordship,
You file your affidavit.
will file, okay? That's why I clarify,
বাকি
Lordship.
খিনি হেৰি কৰি থৈ দিয়ক। I consider prima facie case made of irreparable loss. Same status quo as regards service of the petitioner be maintained, meaning thereby that until further orders, no one should be appointed pursuant to the advertisement dated 8/11/2022.
That's why I'm clarifying, that order I have no objection. Earlier, it's an internal of the college, Lordship. But both department was created, Lordship. All of our more than, Lordship, 20 colleges later on.
Mr. If you go to paragraph 53 of Uma Devi, will the earlier advertisement be a absolutely illegal appointment so that you doesn't give you any right of any kind? And whenever we feel like, we'll,
Yes.
after a decade or so, we'll sanction and you will go after that.
That is true, otherwise.
Court
Lordship,
order.
We'll determine
Changes
this
to
issue.
Lordship.
It don't matter.
Otherwise also that particular issue was Lordship decided that particular.
Then you file your affidavit, we'll hear you.
Lordship has already decided that issue.
কিবা হৈছে?
We'll file affidavit, Lordship will clear back.
এইটো খালি টেষ্টবোৰ নহয় পূৰ্বাঞ্চল আৰু বাকী দুটা দি থৈ দিয়া আছে। Well, list along with the হেৰি কৰি থৈ দিয়ক।
Yes,
We're listing along with the other one.
lost my.
We'll hear it together.
Item 6,
This is also one, same thing. Here,
Please give those advertisement, new advertisement and college.
fine, fine.
Item 8. Item 7, sorry.
Thank you. No, these are for orders.
Which one?
Item 56 and 57, your office passed earlier order. Those are,
57.
they are coming as orders.
56 and 57.
Matishan naki?
No.
No, we are yet to call 57. This
Yeah.
order we have passed in item 5.
Five and
Mr. Cholia says 6 is same.
six.
So 5 and 6 same order. Yes, Mr. Saike.
May this is not. So in this case, the petitioner also township was initially appointed as LDA, but on 30/8/1958. But government followed, as there was no scope for promotion of the LDA member, government took a policy decision to upgrade the LDA's member. That is, the policy decision was still filed page 21.
Petitioner shall file amended writ petition. You have filed. Okay. Now we are taking you on merit.
Sorry for that sentence.
Don't write it. Does not,
Actually, for that
does
member,
not taste very good.
officers of the retail.
See, now this trend has come. Even we are noticing that one court will be criticizing the judge. That is not proper. You set aside the judgment, not the judge. That's a very bad trend and should be discouraged under all circumstances. So similar averments should not be allowed in pleadings also. That's not judging. That is only the man who does, he knows what it is. This trend is noticed of late. Anyway. It will only bring down the reputation of the courts, nothing else. Set aside the judgment. But why you criticize the man who had delivered the judgment? Yes,
Yeah, the record and appeal to the Supreme Court.
no, it's happening of late. It's not a good trend. That's why we are indicating. And this is not the tradition of this Guwahati High Court. We have a very high tradition of ours to be maintained. Things should not be imported. Yes, setting aside the quashing. Nine, 10, 2023, you are assailing. Which page?
Page 40, ma'am. The 30 years of service will have been directed to revert back to the post of SDA.
Come back. returnable to be listed along. আগৰ সেইটো মতে সেইটো কিমান benefit হৈছে।
Amal Das was appointed in 1988
88 as an LDA.
as an LDA.
He is still as an LDA.
And when as a teacher?
Teacher, he was upgraded on 1996 mile. 1996.
Page 41, third paragraph.
What is the provision to upgrade
There's no
Well,
provision
page
from
21.
LDA to agent.
then we have to consider appointment of teacher is a fresh appointment.
Yes.
It has to be.
Yes.
It can have no relation with the earlier appointment as LDA.
And moreover, if the impugn order was passed on the basis of another order in a decision number 5451/2012, where it is honorable court has held that the upgradation of petitioner from LDA to agent is illegal. Question of his regulation of agent doesn't arise. That's para 5 in page 41. Lakshmi Kali Peru. This honorable court has already held that. the
That
person-
that Amal Das is not
Yes. No, this is another person law, in another similar case law.
maybe, but there is a declaration against him. So in spite of that declaration, it will have its effect in this case also. Hmm.
And there is a notice to go, the private husband is also there, Lord.
No, Mr. History, come to paragraph 1, 2, 3, 4, 5. 5 of page 40.
Sri Jyotinder Dekar was appointed as agent teacher.
In the scale of so and so,
In the
and
scale of so and so.
so just read. As admissible as
admitted as per rules.
as per rules. So he was appointed as per rules.
That is the private respondent.
No, Jotin.
Jyotinder is private respondent.
Acha, Jotin is the private.
Yes,
person.
Lord.
You are Amal Kumar Das.
Yes, Lord.
So now what is, so we issue notice.
I've
What
been
kind of
working
interim
as
order can I pass?
I've been working as teacher, my lord.
No, no, we are
Whether-
thinking you are Jotin. So Jotin, I would have given some interim order.
my lord, Lakshmi
So
kindly-
now being Amal,
Yes, Lord. That is
the mine will be just reverse.
my lord, Lakshmi kindly turn to page 21. Page 21, my lord.
Matlab, whether this particular letter is lordship. It is 1993 issued by the Joint Director of Secondary Education, whether it is any relevant at this time. Lordship.
The policy decision of the government, but as there is no scheme for my lord, promotion of the LDS.
No, it is issued by
Who
the
is
government.
SK Chakraborty?
It is not issued from the government, it is from the director of.
No, no, who is SK Chakraborty?
I think he was the then joint,
He is not even director because
Not
it
even
is from the office of the director.
he is joint director. This cannot be.
This is
reason of the
year
government.
1993.
Yes.
1993, everything was happening in the education department.
But even if my-
Education department
even if
was
my-
controlled by few people in around that time. Whatever manner they wanted, things used to happen that way. You should notice.
my lord, even if my appointment is issued to be my lord, ad hoc appointment. If my lord, rule doesn't permit, my lord, I'll be my lord, fresh appointee, my lord,
That's what I am thinking. I can
Then-
consider it to be fresh appointee from 1996.
1996.
Ah.
Then also, my lord, I've entered to pick up my lord, Uma Devi case, my lord, there is a kind of picture of Uma Devi.
No.
Because I was appointed
This
secretary
is what we are
of-
trying to point out. Jotin Dekha was appointed firstly as per rules.
Yes.
No,
Number one.
Yes.
This is the order against sanction post.
Yes.
So as per rules against sanction post, it's a regular appointment. Only thing what happened, that was a centrally sponsored scheme.
Yes.
For a brief period in between, that post was not there.
Yes.
So that will not take away his legal right. Just because of their lashes, the post was not there for a few months in between. So law will presume there to be a continuity in his service. So then he is from 1991, you are from 1996.
But I am not on that matter. I
Then
am on the reversion matter. I have been directed to be reverted back to the post of LDA matter. Today, I am not claiming the seniority matter. That one day. But I have been directed to revert it back to the post of LDA matter.
but there is already a court judgment against you.
That
Now,
was-
if I pass an order, will my order not be in conflict with the earlier court judgment?
Yes, no. In the earlier.
Let us issue notice, we'll hear you, we'll hear them also.
From the time, for the time being, at least not me. Pass an interim order so that
Mr. Sakya, this is precisely I'm asking you. Will my interim order not be in conflict with the final judgment in that writ petition?
5451 of
5451. List along with WBC 5451 since disposed 2000. We'll see. If you can carve out a distinction from the earlier one, we'll give it the interim order.
Well.
In the meantime, maybe direct.
9, 10.
Status quo, we'll record you back, don't
Already a
worry.
month has gone left.
Till that, I have not been reverted. Till that.
I don't.
Anyway, I am not a firm believer in status quo. Either we'll pass an interim order clarifying everything, whether he'll be there or he'll not be there, or I'll reject the interim order. Status quo, I'm not interested. It only adds to the confusion. It doesn't help anybody.
Let's see for Monday, next or Friday.
The other day, in a civil matter, I came across a order of status quo. It's a case of land grabbing. Land grabbing means fraudulently somebody is occupying another man's land. There is a suit. Court gives status quo. What does it mean? You are legitimizing that illegal act. So status quo, maybe in one of these days I may pass your order. Status quo should always precede with an appropriate decision whether the facts exist in X manner or it exists in Y manner. After clarifying, only there should be a status quo, not before that. Otherwise, it's only adding to the, yes, Mr. Dhar, you are in civil. Don't you think so? Status quo is the worst order any court can pass. So status quo should always precede by a determination by the court whether the facts exist in X manner or it exists in the Y manner. Only after that satisfaction is arrived, there must be a status quo. So then the court will be clear whether I'm giving it in favor of the petitioner or in favor of the respondent. Otherwise, it is only creating a confusion. Tomorrow we'll come with a contempt. Then we'll be faced with a determination. We don't know what is the meaning of that status quo. Whether you are in service or you are not in service, no one knows.
My instruction is that nothing reverted back till day. He's working as.
The prayer for the time being for grant of status quo is rejected in as much as it is unclear to the court on the basis of the materials produced as to whether the petitioner is presently in service or he is not in service as an assistant teacher in the school concerned. We are of the view that whenever an order of status quo is to be passed, there must be a prior decision by the court on the status of the facts as to whether the facts are in favor of the petitioner or it is in favor of the respondents. Unless there is a clarity on the status of the facts, a mechanical status quo should not be issued, which will only add to the confusion later on. Come back, we'll pass a definite order if it is. This one, along with the records of the other one.
12 record.
Item 8.
Mr. A.R. Bhuiya,
My lord, it's covered by my lordship's order is at page 91. That really matter,
is it covered, Madam Chutia?
My lord, only difficulty is, my lord, they have, as per this order, my lord,
Then we pass the same order. Ekata Maritio.
my lord, they have filed the representation individually, my lord.
Sorry,
They have filed a representation, my lord, individually, my lord. In this case, they have filed
representation.
individually, my lord, as per the order of this page number, my lord, 92.
Lord, my friend is saying that we have already filed a representation
Collective.
collectively. but
It should
my-
be individual.
Individual.
Yes, we'll add the line
My-
individual. Heard Mr. A.R. Bhuiya, Baki to already do, Mr. B. Chaudhary for SSA. Sorry. Mr. Chisti, are we appearing? No. Mr. Kochi.
Elementary.
Without going into the merits of the matter, it is stated by Mr. A.R. Bhuiyan and counsel for the petitioner that the issue raised in this writ petition would be covered by the order dated 23/6/2023 in WPC 366/2023. The order dated 23/6/2023 in WPC 3667/2023 is extracted as below. The same order would also cover the grievances raised by the petitioner in the present writ petition. However, it is also provided that the petitioners will file individual applications for the purpose before the concerned authority. All other terms as per the order shall remain same.
Order stay vacating item 9 and 10.
Lordship may kindly pass over this matter for time being.
We have
This is for the third time,
Time being, Lord.
time being.
Time being.
Lord.
But don't worry, today we are going to take it up.
Lord.
We'll let it be. You can't, you don't conceive of a situation by time being, you can pass over for the day.
No, Lord.
Okay, come back.
My lord, we take up at 2.
And give you a time. My normal procedure I followed,
Fine.
second round.
Fine.
What to do?
Oblige.
Item 11.
But Mr. Counsel, please remember, even if the list is not completed, before the court rises, this matter will be called.
Need some time because of that. There is a inquiry is conducted by the inspector by the on the basis of director or by the.
Oh, which
So,
item?
Item number 11, my lord. Yes.
11. You want
Because
some
of-
time?
Yes, sometime ago I filed a additional affidavit. So I think
Yes, already director has written to the inspector of school, lordship, to conduct an inquiry, lordship. So, we await that.
You were waiting. You want time.
Yes.
So let us grant him the time. Mr. N. Borwal and counsel
and
for,
Bora.
sorry, N. Boral and counsel. Was list is wrong. Was list told you to be Borua, I think.
Yes,
Mr. N. Boral and counsel for the applicant seeks for an adjournment
2 weeks time to file additional.
of 2 weeks to file additional. Prayer Lord, list after 2 weeks.
Mark.
Order impletement of party item 12.
Whom do you want to implead? J. Abedin P. Ghosh. None appears for the applicant adjourned.
On the earlier 2 occasions, my lord, they remain absent and it lost. There is the order, my last order, lordship, kindly.
It is noticed that none appeared for the applicants on 23/8/2023 and 7/10/2023 to pursue with IS Civil 3175/2022. By the order of 17/10/2023, it was provided in the event of further non-appearance, appropriate orders shall follow. Today, again, none appears. IS Civil dismissed for non-prosecution. Mr. R. Ali appears for the respondents.
Item 13.
Just item 13, what is it?
Yes, please, my lord. As per the direction of the honorable court, my lord, we had filed this implement petition for impeding the respondent. number-
Direction of the court.
Yes, my lord. On my lord,
Where is the direction of the court?
my lord, on 18/9/2023, my lord,
18/9/2022.
the council for the education department.
This is not our direction.
My lord, the council has indicated that,
No, no, accordingly, we have already implemented.
my lord,
Accordingly, BTC in education through its secretary, we implemented. Implement is already over.
my lord, what happened, my lord? As per the direction of, as per the mind expressed by the court, who had approached the registry, my lord, for inserting the name of the respondent number 6 and 7. But they have instructed us to file an IM.
Why?
Just because there is a
Huruf
notification
Singh,
Because of that notification
There
that
is
was
a
issued
what notification?
regarding implement or any amendment in the cost title manual, an application has to be filed.
So,
earlier, we-
then ask the registry to recall this judicial order. How can I? Hey, Harry Kudokum, once there is a judicial order, it to accordingly be implemented. Implementation হৈ গৈছে এতিয়া তেওঁলোকে কয় যে হেৰি এপ্লিকেশ্যন নোহোৱাকে নোৱাৰো asking calling. Yes, we'll take up.
My lord.
Let the registry file an order to recall this order then. Otherwise, we cannot. There is already a judicial order. There cannot be two judicial orders for the same purpose. We'll take up.
Item 14 for admission.
Regularized of service, my lord. 1 to 5 already regularized, and it's the last one.
Tutor.
1 to 5 have been regularized. 6 have been left out.
Or 6, 7 left out.
Only 6. They are directed to file affidavit, my lord, regarding that.
No, no. Yes, Mr. Kaushik. You had regularized the 1 to 5 as tutor.
Hello.
6 and 7 left out.
Only 6.
6 had been left out. Can we have the order by which they were regularized? And whether 6 was rejected or he was not considered?
Yes,
I'll get that.
If he was rejected, there has to be a new writ petition. If he is not considered, we'll direct him to look into his
My
matter.
lord, I'll get that.
Mr. B. Kaushik, line counsel for the respondents in the elementary education department, prays for adjournment to provide the complete records by which the petitioners number 1 to 5 had been regularized as tutors in order to enable the court to verify as to whether the claim of the petitioner number 6 was considered and rejected or it was not considered at all.
Right.
Please no.
Item 15. Hello.
Lordship, we have received the affidavit in opposition. If you would like to get it.
Affidavit, your name?
You sure, ma'am.
Mr. U. Sharma, line counsel of petitioner, prays for
3 weeks. ma'am.
3 weeks. 3 weeks time to file an affidavit to the affidavit in opposition of the respondents.
Item 16. Order.
Yes, 16.
The lordship of matter of senior is of a separating earlier. Since these separate are covered, just to take instruction, that may come up next week, lord.
MS8, but you are good enough.
Lord, I have not prepared. Matter is a bit voluminous. OPB.
You are not
team,
prepared.
Lordship, OPB.
Adjourned on the prayer of MS8 Talukdar Land Council for the petitioner. We listed next week. You come prepared. I think you are
Lordship,
more than good enough.
lordship.
Item 17.
This was for appointment of arbitrator, lordship.
Huh.
We gave a notice to the railway in the 21 of the Arbitration Act. Subsequently, they have issued a letter to us. In fact, a communication, I would rather say. They said that earlier we have availed a writ jurisdiction. And therefore,
Sorry, earlier, what happened earlier?
earlier we filed a writ petition. And then that writ petition was withdrawn by us.
Uh-huh.
So they say that since earlier we have availed a writ jurisdiction, our right for arbitration has been Therefore, we have filed lordship an application, present application under 11 earlier.
So now arbitrator cannot be appointed.
My lord, I filed my affidavit of opposition where I clearly narrated every fact and circumstance of the cases, my lord. The contract agreement was executed in 2011 and it was expired in the year 2014. Some dispute arose regarding the non-payment of the license fee of the vendor. So the railway intimated them so many times, and there are some minutes also. They agreed to make payment of the lump sum payment they have made, but balance amount has not been paid. So they, after termination, they approached to the honorable court by filing way of the challenging the termination order. Later on, when I filed affidavit of opposition, explained everything before the court, my lord, then they have withdrawn, which is on record.
No, is there any arbitration clause as per
Yes,
the
yes,
agreement?
ma'am.
Where is the arbitration clause?
6 of the
Page-
contract agreement.
Page number,
Page number, lordship, there are 3 contracts. One such contract is
page number.
23, 23, lordship. 23, 24, similar contract. Lordship. And just submitting.
No, where is the arbitration
Yes,
clause?
yes, lordship will kindly see 5.6, page 24, lordship.
But even after having arbitration clause 5.6 of the contract agreement, they never approached to the railway for appointment of arbitrator to send the matter for arbitration. They approached to the honorable court by filing W.
Madam Chakraborty, tell us one answer. Whenever there is arbitration clause, if the party resorts to any other alternative forum, either pursues or withdraws, the arbitration clause becomes redundant. Please produce that proposition of law.
My lord,
Please produce the proposition of law which will make the arbitration clause redundant if any of the parties approaches any other forum.
submitting my lord that.
That is the, madam, your words may not be so, but the purpose is that only.
No, my,
That here file a repetition withdrawn, so no more arbitration.
since he is, my learned friend is saying that.
So we are appointing an arbitrator,
My-
go to the arbitrator,
Yes, but.
take any kind of objection you want to take there,
No, my
not
lord.
here.
My lord, I have a decision of the honorable Supreme Court as
Which decision will help you? Let us see.
in this case, my lord. My lord, in this case, the honorable Supreme Court observed that they have set aside the order of the Allahabad High Court by directing that they under clause 64(3) of GCC, railway can appoint the arbitrator. So now.
So you appoint the arbitrator.
Yes, my lord. I can appoint, my lord. Now this decision is being again challenged along with the other CCL, SLP, and which is pending for hearing. So.
So why should we keep waiting for this thing to
Lordship, in this
get
figure-
one?
Lordship may please to direct the railway to appoint the arbitrator.
In this figure,
as
lordship,
from the-
Will you be satisfied if the railway appoints an arbitrator?
in this figure,
The
lordship,
MSU,
may I submit one line? Okay. In this figure, lordship, I have come to one judgment of the honorable Supreme Court, where honorable Supreme Court very specifically stated, lordship, I can produce the judgment, lordship. that
produce
if-
it,
if-
not can.
Because I have.
If you have the
Yeah,
ability,
I'm not
show
having
your
it. I just
ability
read it
rather than
yesterday.
stating your ability.
Absolutely, lordship.
Produce it.
I will
We'll
produce
hear
the
it.
judgment. I just
Ah.
want some time for that. lordship.
You want adjournment?
Yes.
Adjourn on the prayer of Mr.
My-
A. Bhattacharya.
Your name?
A. Bhattacharya.
A. Bhattacharya, Land Council for the petitioner. We'll hear you together. Yes, next item.
Can it be fixed after 1 week?
এখনো তো rightly wrongly order হয়ে গেছে
হয় রয়েছে।
to incorporate so why don't you do it? তেওঁ কৈছে যে হেৰি ৰেজিষ্ট্ৰি মোক কৈছে এতিয়া এপ্লিকেশ্যন নোহোৱাকে আমি নকৰোঁ
না, না, কেন? judicial order তো আছে।
দিছ ইজ এ কন্টেম্প্ট
Judicial order তো আছে।
কোনে কৈছে খবৰ ল who's in the registry told you?
My lord, there is an no office note, my lord. Office note dated 27/9/23.
কোনে দিছে এইখন Yeah, he is sitting over the court judicial order over this man. Ask us to cause him.
Note করে দিয়েছে। IS judicial order আছে আর
No, ask this man to show cause. Why will he pass this office note? এটি এখন কি হল unnecessary I file করেছে for impleading. Once a judicial order is there, how can you pass another judicial order on the same thing?
judicial order না থাকলে IS
Or নহলে ask this man to file a IA to recall that order. Let him file an IA.
I'll look into it.
Poriboni, ask him why contempt should not be drawn up against him. Already Niki. Who is this man? Mati, any put up? One so now section has precedence over judicial orders or what? One senior judicial assistant is above the High Court basically. Ask him, give him a stern warning not to do all this.
Strict admonition.
Not to do all this. When there is a judicial order, who do all that? Who is this man? Or what action taken to please inform? This thing should not be allowed. I had to take over. Close for it with you. Heard
DM Nath. DM Nath.
DM Nath and counsel for the applicant. Also administer. It is noticed that by this interlocutory application, the petitioner seeks to implead the Secretary to the Department of Education BTC Kokrajhar and the Director of Education BTC Kokrajhar as party respondents number 6 and 7. But it is noticed that the BTC in the Education Department through its Secretary had already been implemented as respondent number 6 by the order dated 18/9/2023, requiring the registry to incorporate necessary correction in the cause title of the writ petition as well as in the CIS system. As regards the prayer for impleading the Secretary to the Bodoland Territorial Council in the Department of Education, the matter is referred to the Register Judicial for Joint Register Judicial to examine as to why an office note had been put up, office note dated 27/9/2023 had been put up. As regards the prayer for impleading the Director of Education Bodoland Territorial Council, who appears for BTC?
Mr. Nayak. P. Nayak.
Get somebody, why he doesn't come? Somebody to come from there. I think BTS a number of council are there, not only one.
Yeah.
We heard so and so. The Director of Education BTC is impleaded as respondent number 7, registry to incorporate necessary correction in WBC 5403/2023 and also include the name in the CIS system. Okay. I allowed as indicated.
In the main requisition matter, notice
has
has
not
not been issued. That's because on the very first day of motion, he has indicated that the opponent number 6 and 7, the necessary part.
I am yet to issue notice.
Yes, in the main.
You are appearing for BTC.
Yes, sir.
You appear for 6 and 7. What do you have to say in the writ petition?
I need to update instruction.
What instruction will you obtain?
That
No,
matter
before he started, what instruction will you obtain?
that matter pertains
Yes, what is your matter?
My lord, the requisition was originally appointed as assistant teacher in the year 1995. Subsequently, as assistant teacher. And in the year 2013, my lord, the services of that particular school, my lord, was staff of some of the teaching as well as non-teaching staff of the same.
Provincialized. There after that?
Unfortunately, my lord, my name was left out. So I made an inquiry, my lord, and it is found that my
Mr. Nath, we don't deal with fortunes of people. We deal only with legal issues.
my lord,
So if unfortunately something happened, we cannot change the fortune of anybody.
my lord,
If there is any illegality,
Yes,
please tell us. What is the
the record
illegality?
of the petitioner, the appointment letter of the petitioner was manipulated, my lord,
Manipulated by whom?
by the then headmaster. And he was
Where is the appointment letter? Which page?
annexer 4, my lord,
Page
page
number?
number 33, my lord.
Page number
33.
33.
This is the
This is dated 95.
Yes.
Petitioner is Florence.
Phone number, serial number.
Florence, assistant teacher.
Yes.
The following teacher is who were appointed by the managing committee are hereby provisionally approved. And who had manipulated?
Yes,
Where
my
is
lord.
the manipulated?
My lord, at page 36, my lord. The same letter, but as my lord has rightly, it is as LT, my lord, instead of AT.
For the purpose heard we are including as BTC. For the purpose of claiming provincialization as a teacher in the what is the name of the school?
Subhaijar High School.
In the Subhaijar High School under the BTC, the petitioner raises an issue that he was appointed as an assistant teacher along with one Sri Baroda Prasad Brahma as headmaster. As per the order of the Inspector of Schools, Kokrajhar District Circle, Inspector School, Kokrajhar, dated 28/4/1995. But when the process for provincialization was initiated, the headmaster of the school had manipulated the appointment letter, and the manipulated version of the appointment letter is made available at page 36 and Annexure 6 to the writ petition, wherein after using white ink, the expression AT, that is assistant teacher, had now been changed to LT. LT means language teacher. As provincializations take place, and as the law of provincialization gives individual legal rights to the assistant teachers and the language teachers for the purpose of provincialization, such manipulation, if had been done, would have a serious consequence. In the circumstance, the director of education, BTC, is directed to make a thorough inquiry and submit a report before the court as to whether the Annexure 4, page 33 is the appointment letter of the petitioner as per the records, or it is Annexure 6, page 36. And secondly, under what circumstance the Annexure 6, page 36 had been manipulated by using white ink and incorporating the expression one inverted comma LT. Whereas the color of the type written of the order is otherwise blue, but the LT is written in black ink, meaning thereby it must have been done subsequently. If yes, who had done the manipulation, for what purpose, and if the purpose who had committed the manipulation resulting in the fraud is detected, what appropriate action would be taken against such person? List after 2 weeks for the report from the director, BTC. A copy of the order to MSA. P. Das, then consider paying for that.
Item 18.
Mhm.
I'm praying for the adjournment.
Okay. What matter is this?
In this case, what happened, there was a certain seizure under section 132.
Under the Income Tax Act.
Thereafter, notice under section 131(a)(2) was issued. That has been put under challenge that after seizure, there cannot be inquiry. That is the ground for challenging.
To an adjournment. Adjournment on the prayer of P.K. Bora, and counsel for the petition. Interim, we don't know. For interim, we'll have to argue to continue with the interim order. Then take a fixed date. List on interim to continue till then.
Item 18. 18 is that one. Item 19.
21 I
21.
GK Sharma A Talukdar. Yes, Param Talukdar.
May this is your lordship. Your lordship, here we need to file our affidavit, your lordship. Instruction awaited, your lordship.
MS Speed asked for BTC.
It is
Praise for
3 weeks time.
3 weeks time to file affidavit, prayer law list after 3 weeks.
22
Your place.
to 25.
The matter may be passed over for the time being.
26.
May I please, your lordship?
May this is your lordship. Here, your lordship, our affidavit is ready.
26.
Yes, your lordship.
It's
That has
stated by
signed
MS
for
Speed
vetting.
asked by BTC that the affidavit is ready and it will be filed within a week.
filed.
Pray allowed list after review.
I also filed today itself.
Give your.
On that.
You are welcome.
Twenty-seven.
Yes, Mr. Bhuya.
Lordship, in this case, lordship, we have filed affidavit in the year 2022, lordship.
Want to file now?
No, lordship, we have already filed, lordship. Our reason is that he is very.
You already filed.
Our
Today,
reason-
can we hear the matter?
No, lordship. We have to obtain the further instruction, present instruction in respect of the verification report of the PhD, lordship.
Verification report.
Of the PhD, lordship.
Mr. K. Gogoi, Land Council of Higher Education states that there is a requirement to obtain a verification report regarding the PhD degree of the petitioner. And for the purpose, seeks
After 2 weeks,
an
lordship.
adjournment of 2 weeks. Pray allowed list after 2 weeks.
Committee report to the-
31.
Yes, Pothakur P. Sinha.
Item 31.
Then appears for the petitioner, list again.
Otherwise,
K. Gogoi appears for the Higher Education.
32.
31, as per my lord's direction, we have complied, lordship. He is.
No, he is not coming. Let adjourn.
Obligation.
32, yes.
May this is your lordship. Here, your lordship, instruction is awaited, your lordship.
MSP das BTC prays for 3 weeks time to file affidavit, pray allowed list after 3 weeks. None appears for the petitioner.
34. None
But
appears.
why do you make that prayer? None appears for the petitioner.
Yes, your lordship. Then it.
None appears for the
Before
petitioner
as
list again.
non-appearance, your lordship. Deeply obliged.
If you want, you take time on the next date.
Yes, your lordship. Deeply obliged.
Item 34.
34, who is appearing? None appears for the petitioner. Adjourn.
35.
None appears adjourned.
Obligation.
Item 38.
Yes, Mr. Hamad,
My lord, may I please, your lordship? Matter pertains to my lord, compassionate appointment, my lord.
compassionate.
My lord, the father of the petitioner, he died on one. My lord, he
Okay,
died on 26/12/2010, my lord, and he applied on time, my lord. 12/1/2011, my lord. My rejection order, lord, will kindly find at page 36, my lord. Page 36, my lord. Is the rejection order.
Yes,
One time considered,
where is the rejection by the
my lord,
Dear
page 36. my lord.
36?
My name appears at serial number, my lord, 23, my lord. Last one, my lord.
Hmm. Razaul,
Rajaul Karim.
rejected as mother employed.
Yeah.
32.
Father
None
was
appears
no
for the
more.
petitioner.
So,
adjourn.
like the death certificate of.
Mr. Pegu,
My lord.
mother was employed as?
As my lord. Teacher, my lord, in a school, my lord.
So after the death of the mother, he is entitled to one more right for provincialization, for compassionate appointment.
Yes.
So against the death of the mother, no, the petitioner can apply, my lord.
That's what we are
But
saying.
here, in case of against the father,
Father, you had not, but the rejection date is 23/4/2012.
after that mother, because after that mother was in service. That is why
Okay.
his case was not considered.
But he did
Because
not
once-
apply in respect of his mother, my lord. He applied on time just after the death of his father, my lord.
Where is the rejection of the application for mother's death?
My lord, after the death of the mother, my lord, he did not apply. He applied only after the death of his father, my lord.
Understand,
My
but
lord,
that is rightly rejected because mother was employed.
I'm saying, my lord,
Compassionate you will get only when no one is employed in the family.
regarding my lord, clause 10 and 11, my lord,
Sorry.
my lord, I am praying for one-time consideration, my lord. I was keep in darkness, my lord, regarding my earlier rejection, my lord. Only I could appeal
No.
this particular, my lord, rejection.
But
my
the
lord, because they
darkness
last year,
will, but the darkness shows that the rejection is a right rejection.
are-
How can we interfere with this rejection? So we allow you to file application for compassionate appointment on the death of the mother
My lord, yes, my lord, the direction may kindly be issued.
with no direction, liberty.
That observation may kindly be.
Heard Mr. J. Hamad, learned counsel for the petitioner, also heard Mr. Girin Pegu, learned additional sitting advocate for the deputy commissioner, Morigao, and MSS Tutia for the respondents in the elementary education department. The father of the petitioner, Abdul Qasim, was an assistant teacher in the Tinsukia ME school, died in harness on 26/12/2010. And on his death, the petitioner submitted an application for compassionate appointment on 12/1/2011. The said application was considered by the DLC in its meeting of 23/4/2012 and was rejected by providing that as the mother was also employed, therefore, no compassionate appointment can be met. In the meantime, the mother of the petitioner died on
2/7/2021.
2/7/2021.
Right.
The petitioner assails the order of the DLC dated 23/4/2012 on the ground that the contents of the said order was not communicated to the petitioner, and in the meantime, as the mother had also died, therefore he is be entitled to compassionate appointment. We are unable to accept the said contention in as much as on the day when the DLC passed the order on 23/4/2012, admittedly, the mother of the petitioner was alive and was also employed as an assistant teacher in a government school. And therefore, no infirmity can be noticed in the rejection by the DLC. But however, after the death of the mother of the petitioner, if any further right had accrued to the petitioner, it would be open to the petitioner to make a fresh application for compassionate appointment on the death of the mother of the petitioner. Accordingly, if otherwise admissible in law, the petitioner is given liberty to make any such application. And if such application is made, it would be considered by the authorities as per law.
Because my lord, his mother died, my lord, on 2/7/2021, my lord. Now, if he makes an application, my lord, because the department will go by law, my lord, that stating that the 1 year period has already elapsed. That is also one.
That don't do it, Mr. Pegu. Because his cause of action to file come only today after our court's order.
That much consideration.
If any application is made, the authority take note that the cause of action to file the application arises after the order of the court today.
My lord. And highly obliged.
What is the age of the mother?
Age of the mother was, my lord, 61 when she died. 60.
Then she must not have been in service.
No, I maybe have.
Anyway, you file your application, they'll find out from the
My
records
lord,
what is to be
record.
done.
It is not stated. Highly obliged.
39.
39 who is appears. None appears for the petitioner adjourned.
40.
May pleases you lordship, affidavit is ready, your lordship.
I must read ask for the respondents in the BTC states that the affidavit is ready and it will be filed within a week. Pray aloud, rest after a week.
41.
85. I got the matter pertains to. Sir, here I have got the instructions from the Sarva Shiksha Abhijan. I pray for 2 weeks time to file my.
Mr. B. Gogoi for the responding SSA prays for 2 weeks time to file affidavit. Pray aloud, list after 2 weeks.
Item 45 for orders.
Then we can have to file impleading present.
On the prayer of MSK, Devi Land Council for
Contempt petition.
30. None
which order had been violated?
Earlier, actually, I took time.
I know which order had been violated.
Page, my lord, 13, it starts.
Page 13. Where is the direction?
Having agreed to the appropriate submission, advance the repetition or dispose of directing placement of the case of the repetitioner before the high power committee.
And now whom do you want to implead?
Present incumbent. It
Eh,
has already been.
No, the incumbent in which post?
Oh, secondary.
Director.
Commissioner and secretary, my lord commissioner and secretary.
Do you have a commissioner now? Because your department is very
Now to it has changed.
secretary.
Yes.
Heard MSK Devi Land Council for the petitioner, also heard Mr. SMT Christie Land Council appearing for the respondent contemners in the secondary education department. This contempt petition is instituted alleging willful and deliberate violation of the order dated 17/6/2014 in WPC.
WPC,
Which one is yours?
2575, 2013.
2575
2013.
No, that is of Atwar.
Yes, my, this is
Which-
analogous matter.
I know analogous, but where is Atwar's order? That is the order of Fazal, Saif and
Yes.
Onukul. Where is the order in favor of Atwar?
Atwar is another one, that is page 9. Number 1 petitioner. That is order dated 2/4.
For Kikolu for willful and deliberate violation of the order dated 17/6/2014. It is noticed that the order dated 17/6/2014 had been passed in respect of WBC 2575/2013, 2416/2013 and 1459/2012. The petitioner instituted WPC 1213/2009, which was disposed of by the order dated 2/4/2014, providing that the provisions of the order dated 17/6/2014 in the aforesaid 3 repetitions would also cover WBC 1213/2009. By the relevant paragraph in the order dated 17/6/2014, the following is provided. A reading of the order makes it discernible that there is a direction to the respondents in the secondary education department to place the claim of the petitioner Atwar Rahman before the high power committee. We have noticed that this is a contempt petition of the year 2016 and 7 years have gone by.
Yes.
And now the petitioner seeks to implead the present incumbent secretary to the government of Assam in the secondary education department. Instead of allowing the secretary to be impleaded, we are the view that the interest of justice would be more met on a direction being issued to the secretary to the government of Assam secondary education to place the claim of the petitioner before the high power committee as provided in the order aforesaid order dated 17/6/2014, which should also be applicable to the petitioner.
And
the,
and
on the aforesaid consequential benefit, contempt petition closed.
it is not placed by this time.
If it is,
Not clear.
if it had already been placed in the meantime, the result thereof be informed to the petitioner, and in such event, no further requirement to place.
Yes. Hello, bless.
Let's close this.
Close, close.
46.
46, we have issued a compliance order, Lordship.
Where is the direction? Mr. Chisti, where is the direction of the court?
Sorry, Lordship, that brief is that as I
Just a minute. None appears for the petitioner. Mr. SMT Chisti, learned counsel, appears for the respondent containers in the elementary education department of the government of Assam. This contempt petition is instituted alleging willful and deliberate violation of the order dated 13/5/2023 in WPC 1490/2021, wherein a liberty was granted to the petitioner to file an appeal under section 14 of the Act of 2017. He gote pura naam to di diba. A Provincialization Act before the secretary to the government of Assam in the elementary education department. And in the appeal, the petitioner would be at liberty to place all such material as he may desire to rely upon. And upon doing the needful, the appellate authority to dispose the appeal within a period of 45 days. In other words, we have to understand that there is a direction to the appellate, that there is a requirement of the petitioner to file an appeal under section 14, and a further requirement of the appellate authority to pass order thereon within 45 days. In response thereof, Mr. SMT Chisti, learned counsel for the secondary education department, has produced an order dated 16/3/2023 of the secretary to the government of Assam in the school education department, wherein a consideration was given to the appeal under section 14 of the petitioner, and an order thereof had been passed. In view of the above, we see no further willful and deliberate violation of the order dated in WPC so and so. Accordingly, contempt petition closed. How petitioner granted liberty to assail the order dated 16/6/2023 if so advised. We are conscious of the aspect that we are passing this order in the absence of the learned counsel for the petitioner. However, taking note of the attending circumstances as indicated above, that there is a direction requiring the petitioner to file an appeal and for the respondents to dispose of the appeal, which had been done.
Yes.
We are of the view that we are not required to wait for the petitioner for his appearance any further. And secondly, we also take note that contempt is a matter between the court and the contemner, and it is for the petitioner only to bring it to the notice of the court that there is a violation.
Apply.
Closed as indicated above. Copy of the order kept on record.
47.
Yes, Mr. Ali. Contempt.
May I please, Lord?
Notice is issued. Office note of 16/11/2023 shows that neither ID card nor unserved notice had been received back. Await service report. On the prayer of Mr. R. Ali, petitioner to take first steps to register post on the soap container.
48.
Fresh steps taken, Mr.
Yes, office note dated 1/11. It is completed.
But this is postal track.
No, thereafter, your lordship, that flag Z, your lordship, record flag Z, your lordship, it was the initials of the recipient.
Acha, it shows.
Yes. Lordship has directed us on 22nd 9. Thereafter, the office note dated 1/11 reflects.
Because
Yes.
contempt, you can't proceed on the basis of postal flag.
Yes, yes. We have taken a step again, your lordship.
Who is this contemptor?
Your lordship, page 17.
The name of this contemptor?
Secretary.
Secretary?
Yes, yes.
Secretary of what?
Element.
Secretary School Education combined education.
You represent?
I have already informed of it.
It's taken note that by the order date 22/9/2023, fresh steps was required to be taken on the responding contender, and accordingly at flag Z. What is this one
In fact,
called?
your lordship, the
One
record-
acknowledgement due is available,
not-
which shows the initial. And accordingly, notice. And accordingly, notice is accepted. Mr. SMT Chisti, Learned Counsel for the Secondary Education Department, is required to confer with the secretary and if required, to appear in the matter. If you don't appear, you tell us.
I've
2023, we took steps upon the all the respondents. By more particularly respondent number 4 and 5 by Dusty Service, Your Honor.
No, here we notice is issued. Now what happens?
Now,
Notice served.
has been served, duly served. No response has been.
All the respondents have been served.
Sorry,
You want to give any reply?
we will file it.
Mr. A. Tobila, Learned Counsel for the Higher Review, prays for 4 weeks time to file the affidavit, prayer law, this after 4 weeks.
Okay.
Yes, sir.
In this case, I'm appearing for respondent number 3, my
Notice had been issued. You were appearing for 3.
3, my
Want to file affidavit?
2 weeks time.
Mr.
Jail.
J. Loskal, Learned Counsel, respondent number 3, prays for 2 weeks time to file affidavit, prayer law.
Obliged.
This after 4 weeks, take it 2 weeks.
51.
51 I for what purpose, madam?
Amendment of the application, we have filed it for.
Amendment of the writ petition.
We want to incorporate a subsequent development which has taken place. In the main writ petition, we are challenging the finding of the DAC regarding.
Is there any interim order in the main writ petition?
No. Status quo as regards holding the.
You do one thing. We allow you to file a fresh writ petition. You have to file it within 15 days. Till 15 days, we are maintaining the order of status quo. It will be easier for you than going for amendment. Amendment is they will object, we will hear. Your purpose will be served. File a new petition incorporating everything. And whatever interim protection you are having will continue for 15 days. You file it within 15 days. Or else we issue notice in this one. It will take another few months to settle this amendment. Which one you want? Third, Mr. D. Borgohain, Learned Counsel petitioner, applicant issue notice returnable 6 weeks. Steps were registered post 3 days. And you were accepting on behalf of somebody?
Yes.
For which?
Department, respondent number 1.
Mr. Sharma takes notice on behalf of the respondent in the Secondary Education Department. But it will be a much longer process, madam.
Lordship, I understand, but.
But do it.
Client or lordship it has to.
Go as per your client.
Or will.
Yes, next time. No, we have already called the next.
52.
No affidavit has been filed.
Sorry.
No affidavit has been filed by the respondent.
Matlab, sometime it's required, my lord.
Mr. Sharma, you are full,
Secondary.
no, your initial,
You sure?
you, sir, Mr. U Sharma for a say praise for how much time? 3 weeks, 4 weeks time to file affidavit, prayer law list after 4 weeks.
53.
May please wait. My lord, in this matter, CIT report was asked for regarding tone of answer script in the examination. And Pavitra Soikia was interested.
My lord, I have instruction to pay for some more time to get the report.
Adjourned on the prayer of Mr. Green Pegulan, additional senior advocate, appearing for the,
But our name is not there, my lord, but.
appearing for the state CID with reference to the order dated 11/9/2023. List after 2 weeks.
2 weeks.
My lord, on 38th, man. Some urgency is there.
38.
Only thing is, my lord, the petitioner and her daughter were examined by the CID on 6th of November. Today is 28th of November.
Yes,
So we
get
are
the
expecting that they will come up with the report.
report. As paid for list on 30.
54.
May I please?
Mr. Boshio, this is a very peculiar matter. Every answer script has been torn.
My lord, what I want to inform that they are agreeing, of course, not on record, they are agreeing to allow us to for
Re-examine, yeah, you can settle it.
he yet to receive that instruction on.
Madam Bora, we are also not putting it formally. If you can, let the candidate sit for a re-examination, you assess it. No, no, your oral is good enough. We give great value to the words of Madam Bora. Your oral statement is also good enough for us. Number 8 means?
Only 8.
Yeah, Mr. Bosho, we expressed the word peculiar, both are possible. One, a candidate absolutely doesn't know anything, so confused, let me tear it and give it to, and later on I raise an issue. Other possibility is there, somebody may do a mischief in that also. We don't know which one.
My problem is this. In English and other paper, he did well. Above 90. Now,
Mr. Bosho,
kindly, my lord.
your client may be an Englishman, but may not be an Assamese man in another subject.
My lord, she failed in biology. So she appeared on that paper. In other 3 papers, she passed with 40 marks and all. 40 or less than. So
Okay, we'll hear you. Let the report come. No other way.
if she failed, my lord.
And without the report, if you want to give an opportunity, give the petitioner, if you feel so.
The opportunity, all this case appeared in the comfort.
You don't have to be so technical also.
Let me take instance.
Okay.
I will say something.
Next year, allow the student to appear in the.
If she failed, my lord, it would have been differently. But she would have appeared.
Okay, we'll hear you, but I don't know where it will ultimately lead to.
But that is terrible. Only the minor.
We just thought that if both of you agree, maybe to protect the student. I know, you for the school, I think. But one more aspect will be there. If the candidate had herself torn the paper and submitted, the invigilator ought to have been vigilant enough at that time itself that I am not accepting this one.
They have neither made the invigilator a party. They have not made, in fact, after my instructions only, they have impeded us as party respondents. So how can we get instructions on that? The invigilator was in fact from a 3rd school, from DPS Dhaligaon. He was not even from NVS or from KVS.
You are from which school?
I'm appearing for the respondent numbers 2 and 6, NVS as well as KVS. I'm the standing on.
Means the student was a student of that school.
Studying with us and was sent to the Kendriya Vidyalaya of that particular place. What is the place? Bongaigaon, I think. Bongaigaon for the center was in Kendra Vidyalaya. But the center in charge.
The
of that particular
CBSE to also submit a report before the court that if the student had torn the answer scripts and then submitted as to who was the invigilator
No, it's only there, Your Lordship. That is,
and why the invigilator had accepted a torn answer script.
No, that cannot be find a lordship. The examination,
she has torn the center sheet, Your Lordship. So on the top, the sheet remains the same. When the child is.
Sorry?
Lordship, from the center fold, there are several sheets. This is the book. If I tear away 3 pages from here and I submit it like this.
Okay, it will be
and this is
difficult
not-
to.
this is not- The invigilator will not know. She has submitted it like this.
when he received the.
Let the report come.
Lordship.
All these are presumptions.
Yes, next item, item 50, 50, 70, sir. 82 to 7. 7, no, 82.
3920.
T920 Deepak Kumar Bhagat. Next one, it all piece of long. Paisa.
Item 54.
Yes, notice. You want to give reply? No, no, only notice is issued. Do you want to give reply?
Last order kindly. Interim prayer was to be considered today. But actually, by dint of a fact degree, the respondent number 5 is working as the headmaster.
1 week time.
And we have brought the information from the college, the university authority.
What is the matter, Mr. Yes, you argue? Mr. Mahmood, what is the
This,
matter?
my lord, this respondent number 5 is, has produced a certificate that he has passed BSc examination in the year 2015.
No, this is dispute is regarding what? What is the prayer?
That is page 28. But we have.
I know.
38. And then.
Honorable respondents to show cause as to where Salomdi issued to remove the private 5 after proper remove. In what post is he serving? Respondent number 5?
Headmaster.
Headmaster.
Yes.
So you want to remove him. Who is this petitioner?
The petitioner is a teacher of that school.
He is a
Actually,
teacher of this
He is
school.
eligible to get the post of
If
headmaster.
this man is removed, petitioner will come in.
Yes,
And why do you want to remove him?
because his degree is high.
Huh?
His degree is high.
Page number?
Page 28, kindly see. Page 28. Praveen Narayan Dev.
Huh?
He has said that in the year 2015, he has passed BSc examination from Chovid University. Now, Lordship may kindly see page 40 and extra 16.
14.
Since 2014, that university
Page
has
number 14.
40.
40.
Yeah.
What is this document 40?
40 we have obtained from through RTI information.
This is website information or RTI information?
Website.
My lord. Regarding the test 38, inquiry report is
30?
38.
38.
See,
Heard Mr. M.U. Mahmood, Learned Counsel for the petitioner, also heard Mr. J. R.K. Musahari, Learned Counsel for the respondent, in the Education Department of the BTC and Mr. B. Kaushik, Land Counsel for the respondent in the Elementary Education Department of the Government of Assam. By the order dated 21/8/2023, notice was issued, returnable 4 weeks, with a further provision that the prayer for interim direction shall be considered on the next returnable date, and according the matter is listed today. Mr. M.U. Mahmood, Land Council petitioner, submits that the petitioner Deepak Kumar Bhagat is a teacher in the which school?
Raja Ajit Narayan.
In the Raja Ajit Narayan Dev Girls ME School in the Chirang district. The petitioner is aggrieved to the extent that the respondent number 5, Praveen Narayan Dev, is allowed to be the headmaster of the school, and according to the petitioner, the what degree? This is B.Ed or what?
BSc.
That the BSc degree obtained by the respondent 5, Praveen Narayan Dev, is from Shobhit University through the distant education mode. How? Full stop. By referring to Annexure 16, page 40, which is download from a website, it is urged upon that the UGC had not granted approval to the distant learning course of Shobhit University, and therefore the BSc general degree obtained through the distant School of Distance Education would be untenable in law. Although we had given an opportunity to the respondents to respond as to whether the BSc general degree of the respondent number 5 is acceptable in law, comma, no further material is produced other than Mr. R.K. Musahari, Land Council BTC, referring to a communication dated 30/7/2020 from the District Elementary Education Officer Chirang, wherein it is provided that upon corresponding with Shobhit University, they had verified and informed that the certificates of the respondent 5 are genuine. The question is not whether the certificates had been genuinely issued. The issue is whether Shobhit University under the law can give a BSc general degree through the distance education mode. No material is made available. In the event the BSc general degree of the respondent number 5 is unacceptable in law, we have to understand that the respondent number 5 does not have the authority of law to be the headmaster of the school. In view of the prima facie case being made out, it is directed the respondent 5, Praveen Narayan Dev, be restrained from being the headmaster of Raja Ajit Narayan Dev ME School, Basugaon, until further orders. Further orders shall be considered upon the respondents producing relevant material before the court to arrive at any conclusion as to whether the BSc general degree issued by Shobhit University under the distant education mode would be acceptable in law.
My lord, Shobhit
Next
University may be necessary party.
Why should they be party? He is not seeking any relief against them. The prayer for making Shobhit University a respondent is rejected in as much as no relief has been claimed against Shobhit University in this writ petition, and not they are a necessary party.
My lord, yes, sir, these website downloaded.
We have already called item number 56.
56.
Are you appearing? Notice আছে already. List after 4 weeks.
I've been directed to take this by Justice
You
Service.
want to say something?
Yes, sir. I'm appearing on behalf of the respondent number 5.
5. So we take note, your name, madam?
KM Saikia. KM Saikia.
KM Saikia, Land Council enters appearance for respondent 5 and phrase 4. How much time you want? 2 weeks time to, it take 3 weeks, but file it. For 3 weeks time to file the affidavit, pray aloud. Number 4,
Number 4 is the,
has he been served?
yes, I was directed to take Justice Service, Miller.
You have taken Dusty.
I have taken, I am filing the affidavit.
As regards respondent number 4, the petitioner prays for an adjournment to file the relevant affidavit, which may indicate that Dusty notice had been served. List after
3 weeks.
4 weeks.
4 weeks.
Forward. 57.
I'll be,
Lordship,
he's also identified.
Lordship, in this matter, I am appearing for 4 and 5 respondent number.
Which one?
57 item.
Acha, next is 57.
57.
KM Saikia, Land Council petition enters appearance for respondent of 4 and 5 and prays for 3 weeks time to file affidavit. Pray aloud, list after 3 weeks.
It may be closed, Lordship. Already relieved his hand.
Which one?
57.
57.
In item 57, I am for the petitioner, Lordship.
Okay, not 57, you were there.
Item 57 and 9.
No, item 57, Mr. Cholia is there. I think this order will remain.
My
She entered a bit.
Item 58 for hearing. It was only 3 weeks.
Yes, Mr. Khan, what is this?
And that the petitioner letter is relating to promotion to the post of headmaster. Well, during the pendency of this petition, the petitioner has already retired from service, Lordship. Now he's seeking for personal benefit.
Mr. Kaushik, the records of the selection of headmaster of NNTC MV school. With reference to the order dated 12/9/2023, the records of selection of headmaster of NNTC MV school be produced before the court on the next returnable date, list on
2 weeks. 2 weeks. 3 weeks.
3 weeks, 4 weeks,
Highly of late.
or 5 weeks.
4 weeks.
4 weeks. 19 December. Item 59 for withdrawal.
T. Chakravorty, you want to withdraw this?
Withdraw it.
Mr. T. Chakravorty, Land Council petitioner states that there is a instruction from the writ petitioner not to press with this writ petition in the present form any further. In view of such statement, writ petition closed. On being not pressed, liberty granted to petitioner to approach again if so advised.
Deeply obliged.
61 for motion.
Regarding Lordship compassionate appointment. And that initially, the DLC rejected on the ground that petitioner father did not have balance.
Which page?
Well, that was challenged before this honorable court and close, that particular clause has been set aside and remanded the matter to the DLC. Now DLC has recommended and placed before the SLC, but SLC has not been taken. That is Lordship, page 74 is the DLC.
74,
My-
SLC,
No, DLC
DLC page 74.
and 76.
What
the-
is this name of this man?
My lord, 76,
Saraswati Saikia.
Page 76 middle.
Page 76. DLC of which date?
Very good.
76.
Recommended for grade 4.
Okay, now where is SLC?
Well, SLC has not considered, that is the grade.
Not placed.
No,
Heard Mr. M. Khan and Council, but he also heard Mr. Green Pegul, Learned Addition Senior Advocate for Deputy Commissioner,
No, state level also, man.
for,
2 and 4. State level
for the Chief Secretary and the Deputy Commissioner Karimganj, Mr. B. Kaushik for the respondents in the Elementary Education Department. The petitioner Saraswati Saikia made an application for compassionate appointment. On the death of a father, who was serving as a
Grade 4 employee.
grade 4 employee in the
Formosi LC Bordoloi ME School.
Kivaki Bordoloi ME School, and died in harness on
That in under membership 21/3/2017.
21/3/2017.
Right.
On his death, the petitioner submitted an application for compassionate appointment on what date?
17/6/2017.
76/2017. The DLC of Karimganj district in its meeting of 28/2/2019 had rejected the application of petitioner for compassionate appointment by providing that the deceased had less than 3 years of balance service, by referring to clause 1 of the OM dated 1/6/2016. When the being aggrieved, WPC 7947/2019 was instituted, which was given a final consideration by the order dated 31/2023, which observed that clause 1 of the OM dated 1/6/2016 had been interfered by the court, and therefore the requirement of 3 years of balance service would not be applicable any further. Accordingly, the matter was remanded back to the DLC. The DLC, upon a fresh consideration by its resolution dated 26/6/2023, had recommended the petitioner for appointment as a grade 4. The limited grievance raised is that the state recommendation had not been placed before the concerned SLC, although there is a requirement under the law. In view of the limited grievance, the Director of Elementary Education Assam is directed to place the recommendation of the DLC dated 23/6/2023 before the next available SLC for its consideration under the law.
62 for orders.
62 losses, we have already complied with the order of this honorable court lordship. The direction was to consider the prevention of the petitioner losses, and we have got the speaking order. He was appointed as
heard-
managing committee lordship.
Lordship, Ukaladama has not been filed. Service has been, notice of service has been completed.
No, I am,
And
as a
Lazima-
department lordship, I haven't filed.
Lazima Court also passed orders on dated 17/11/2023. The service is completed. So matter may be listed for admission.
I would like to know.
You are appearing alone or you have some senior with you? What is your name?
Yes, Lordship.
আপনার নামটা কি?
R.K. Das.
R.K. Das.
He is along with others.
PP suit কোন? PP suit আপনার সিনিয়র নাকি?
No, no.
আপনি সিনিয়র?
I'm
Heard Mr. R.K. Das, Land Counsel for the petitioner. Also heard Mr. S.M.T. Chisti, Land Counsel appearing for the respondents in the elementary or
It is secondary lordship.
secondary education department. This contempt petition is instituted alleging willful and deliberate violation of the order dated 8/2/2023 in WBC 8217/2022, wherein in paragraph 3, it had been provided that wherein a direction had been issued to the respondent number 2 therein, namely the Director of Secondary Education Assam, to consider and dispose of the representation made by the petitioner dated 7/12/2022. Mr. S.M.T. Chisti, Land Counsel for the petitioner, has for the respondent containers have produced the order dated 18/3/2023 of the Director Secretary Education Assam, by which the representation of the petitioner dated 7/12/2022 has been given its consideration and the order thereon had been passed. As the representation petition had been already considered and an order had been passed, we see no further willful and deliberate violation by the respondent contenders of the order dated 8/2/2023 in WBC 8217/2022. Contempt petition accordingly stands closed. However, petitioner given the liberty to assail the order dated 18/3/2023 if so advised.
I have already given.
Time being item 9 and 10.
It is taken note, so that the Lajima Court by the order dated 7/11/2023 had relied upon the method of tracking the consignment report from the postal department in order to arrive at its satisfaction that the notices on the respondent contenders had been served. A contempt petition may lead to serious consequences against the contempt petitioners, and therefore it is always advisable under the law to ensure that as to whether the notices had been actually served or not, rather than going on a law presumption regarding service. Therefore, said be brought to the notice of the Deputy Registrar Bench to take note of in respect of notices in respect of contempt petitions. নহলে মানুহে তাক জেলত পঠাব নোৱাৰিতো সেইবোৰত। And 10.
But we have filed this IF.
14/9 who appeared? You appeared.
40.
14/11/2023 who appeared?
I appear.
No, some A Borua is written. That's why I'm like.
But this I document taken. I 1580. To where for vacation of this order dated 13/5/2022.
Did I hear it on 17/10/2023?
Yes, sir.
Let me read that order so that from that stage I can continue to read. Holding the same book.
Yes, 576.
576. Okay, Article 30 schools are excluded. You are relying on 2012 12 SCC 331. Yes. Now who will start?
Since your lordship is stay vacating,
No, whosoever starts will get a opportunity of giving reply. So between you
So
two,
far
you,
as your
you will elect who wants to submit.
lordship, so far as your lordship, my first round is concerned, your lordship, there is no point arguing that your lordship, since it's exempted by the act itself, your lordship, and they have brought uh, certificate that shows your
Ah.
minority.
Hmm.
So that point has done.
Hmm.
So I don't have anything to submit.
Ah.
Based your lordship, even my case is your lordship, even assuming for a moment that this is not applicable. Your lordship.
Which
Even
one is not applicable?
this particular act is not applicable.
Okay, still REIT will be
Still,
maintainable.
it is maintainable.
Ah,
That was my case on the last occasion when the matter was.
Okay, under which provision of law?
Lordship, that is your lordship, my case was, I have, therefore, your lordship, I have relied on this judgment. Your lordship.
Or which one?
It is 1989 to SCC 596.
1989, so.
Your lordship may go through it. I have handed over one copy.
So you were basically,
So I'm over it.
no, some things are here on
1989
record.
to SCC 690.
2023 4 SCC I have with
Yes, your
me.
lordship has, that-
National Commission of Minority, some act I have it with me. And Assam Non-Government Education Regulation Act. Okay, that is anyway, the book is there. Huh. You have it with you?
lordship, so yes,
এখন ওলাই দিব পাৰিবা নেকি? 989 2 SCC 691. Which paragraph you rely upon?
there are 20 onwards.
20.
Oh, Martin.
And also 22 years. And your lordship, so far as your lordship on last occasion, your lordship has pointed out to one judgment of 2023 for SSG, your lordship. I think that your lordship, this goes against me. Detailed judgment, your lordship, the para 75 onwards, your lordship.
No, that one I have it, it's here.
2023
Hmm.
for SSG 498, your lordship, that goes against me.
Just a minute.
And both by
Hmm.
Forum of Future.
For Ase,
St. Mary's.
St. Mary's Education Class.
No puedo. Hablamos que ya ফোন করে না ফোন করে
Yes.
Lordship. So far as this judgment is concerned, your lordship, after this judgment, probably your lordship. My case has also been dealt with by this judgment. But with the utmost respect, your lordship, I can only submit, your lordship, that the context in which this 89 judgment has been passed, your lordship, probably, your lordship, the Honorable Apex Court, your lordship, did not consider, your lordship, and that context, your lordship, is reflected from para 22 first.
And so we have read that, not considered by the Supreme Court.
Lordship, my humble.
Then how can
But your lordship,
the,
ultimately both the judgments.
no,
are
how
very
can
good.
we say that the Supreme Court was
Lordship,
did not consider it wrong?
That's I understand. Your
Mm.
both the judgments, your lordship, and the later judgment, your
Not later judgment. This Andi Mukti was considered.
Adimukti was considered.
You know, you come
Distinct
to
with
page 533.
Para 38.
Before that, you come to page 522. This KK Saxena principle had been very heavily followed.
Lord.
KK Saxena says that even if it is a state within the meaning of Article 12, 226 would not lie against a person or body. It would not lie to enforce a private law right. So again clarified later on, therefore, if writ petition would be maintainable against an authority which is state under Article 12, before issuing writ, court has to satisfy that the action of such authority which is challenged is in the domain of public law distinguished from private law. Now you come to para 535, the page 535, that para 70, that quotation of Uttam Chand, that there is a thin line between public function and private function discharged by a person or a private body. Writ petition would be maintainable only after determining the nature of duty to be enforced, and rather than identifying the authority to whom it is issued. This Montfort school may be discharging public duty as per Andi Mukti. But before issuing writ against them, we should. What is the nature of the duty that is sought to be enforced? Salary. It's a private contract. Now you come to, thus contracts of a purely private nature would not be subject to merely by reason of the fact that they are structured by statutory provisions. Para 75, that quotation of para 34. But if you read 75.1, everything is clear. An application under 226 is maintainable against a person or body discharging public duties or public functions. Public duty cast may either be statutory, similarly for ascertaining the discharge of public function, it must be established that the body or the person was seeking to achieve the same for collective benefit of public or a section of it. Even if it is presumed that an education institute is imparting public duty, that is the other decision, that 2012. It is indisputably a public law action which confers the right upon the aggrieved to make 226. So you may be a discharging public to the applicable, but it must be consequently held that a body may be discharging public function or performing public duty, and thus its action becoming amenable to judicial review. Its employees would not have the right to invoke the powers of the High Court conferred to in respect of matter relating to service, where they are not controlled or governed by statutory provisions. While such of those functions would fall within domain of public or public duty, The action or decision taken solely within the confines of ordinary contract or service having no statutory force cannot be recognized as being amendable. So it's very clear.
In this judgment, your lordship close my door for your lordship.
We close, we give you liberty to file appropriate.
Lord.
That liberty we give you. Close the petition itself, nothing will remain. That's why I asked you whether you will start or he will start. Heard Mr. S. Pothakur, learned counsel for the petitioner. Main read খনতে লিখিব writing order in a main read petition. Also heard Mr. B. Kaushik, learned counsel for the respondents in the secondary education department, and Mr. A. Dhar.
234.
Should I put your name also? Huh? Learned counsel appearing for the respondents under the authority of the Montfort School, Chabua. The petitioner is a teacher in the Montfort High School, Chabua, in the Dibrugarh district, and is agreed by a communication dated, where is it?
Your lordship, that is at page
4/4/2022.
Lord.
A communication dated 4/4/2022 from the authorities in the Montfort School, by which the petitioner was discontinued as a teacher in the school. In the communication dated 4/4/2022, certain reasons thereof had been stated as to why the petitioner is being discontinued. When the writ petition was moved on 13/5/2022, the petitioner took a stand that although the Montfort High School is a privately managed high school, but they are governed by the provisions of the Assam Non-Government Educational Institution (Regulation and Management Act 2006). Full stop. Accordingly, in the order dated 13/5/2022, it was taken note that although 3 reasons had been stated in the communication dated 4/4/2022, and the communication also refers to certain show cause notices, but the show cause notices did not pertain to the allegations referred in the order of discontinuing the service. And on the other hand, they were related to some other institute. It was further taken note that under section 15(2) of the Act of 2006, which according to the petitioner was applicable in the facts and circumstances of the present matter, comma, there is also a requirement of providing a reasonable opportunity of being heard before an employee of a non-governmental educational institution can be dismissed, removed, or reduced in rank. Accordingly, a prima facie view was formed that there was an aberration of the requirement of section 15(2) of the Act of 2006. Objections were raised by Mr. S.M.T. Chishti, Learned Counsel for the respondents in the Secondary Education Department, that the respondent institution being a private institute, writ under Article 226 would not be maintainable. But however, Mr. S. Borthakur, Learned Counsel for the petitioner, relied upon two pronouncements of the Honorable Supreme Court rendered in Marwari Balika Vidyalaya versus Asha Srivastav and others, reported in 2020, 14 SCC 449, and Ramesh Aluwalia versus State of Punjab and others, reported in 2012, 12 SCC 331, wherein it had been held by the Honorable Supreme Court that a writ petition under Article 226 of the Constitution would also be maintainable against a private unaided education. Accordingly, considering the nature of the prima facie case made out regarding not following the provisions of section 15(2) of the Act of 2006, and also in view of the reliance of the petitioner upon the pronouncements of the Supreme Court in Marwari Balika Vidyalaya Supra and Ramesh Aluwalia Supra, which rebutted the objection raised by Mr. S.M.T. Chishti, Learned Counsel for the Secondary Education Department, comma, an interim order was passed providing that the communication dated 4/4/2022 shall remain state until further orders. In response thereof, the respondents in the Montfort High School have instituted IA Civil 1580/2023, seeking for a recall of the interim order dated 13/5/2022. By raising the contention that under section 2 bracket small Roman 15 XV of the Act of 2006, people that under comma, an institute governed by Article 30 bracket 1 of the Constitution of India would not be included in the definition of a non-government educational institution. And therefore, the provisions of the Act of 2006 would be inapplicable in respect of the respondent Montfort High School. It being inapplicable, it is the further contention that as the interim order was based upon aberration of section 15(2) of the Act of 2016, therefore, the interim order requires a recall. In response thereof, Mr. S. Bothakur, Land Counsel for the petitioner, relied upon the judgment rendered by the Honorable Supreme Court in Ramesh Ahluwalia Supra, wherein in paragraph 12, a proposition had been laid down that a private body, if performing public functions which are normally expected to be performed by the state authorities, such public bodies would be amenable to a writ jurisdiction. Accordingly, it is the contention of Mr. S. Bothakur, Land Counsel for the petitioner, that even if the provisions of the Act of 2006 would be inapplicable in respect of the respondent Montfort High School, but the manner in which the services of the petitioner was discontinued, the procedure adopted in discontinued would clearly lead to a violation of the principles of natural justice. And therefore, placing reliance upon the proposition in Ramesh Ahluwalia Supra, it is contended that a writ petition against the respondent Montfort High School would be maintainable, and the impugned action of discontinuing the services of the petitioner by following a procedure which is in violation of the principles of natural justice would render a writ petition under Article 226 to be maintainable. When the matter was heard on 17/10/2023, as the core contention of the petitioner is based on a maintainability of a writ petition, even in respect of a private educational institution, without referring to the institution to be governed by Article 31 of the Constitution. To start with politically. To make it to make it
The core concept of different even in respect of a private education institution, without reference to the government by 31 of the Constitution made.
By submitting that the petitioners do not rely on the aspect that the respondent institute is a minority institution under governed by Article 31. But on the other hand, divorce the provisions of the Act of 2006, they intend to raise an issue that the procedure adopted by the respondent Montfort High School in discontinuing the service of a petitioner is in violation of the principles of natural justice, and therefore a writ petition would be maintainable in as much as the school is discharging a private function, discharging a public function. In this circumstance, the parties were required to look into a later decision of the Honorable Supreme Court rendered in St. Mary's Education Society and another versus Rajendra Prasad Bhargava and others, reported in 2023 for SCC 498. Full stop. In the aforesaid background, the matter is being heard. As a decision rendered in the issues raised in the application for recalling the interim order would render a final decision on the issues raised in the writ petition, we accordingly proceed in the hearing, considering it to be a hearing of the WPC 3111/2022 itself.
If there are two writ petitions. There is another writ petition filed by the petitioner challenging the order of suspension later on. She was not terminated.
It is also taken note that there is another writ petition by the same petitioner against the respondent Montfort High School, which is 3576/2022, by which an order dated so-and-so 18/5/2022, whereby petitioner was placed under suspension, is also essayed. Accordingly, both as the common issues are involved in both the writ petitions, we propose to hear the two petitions together and intend to adjudicate it through a common order. You are not hungry? Are you not hungry?
Leave it to your lord.
Sorry.
We leave it to your since your lordship is.
If I am hungry, I'll go. If I am not hungry, I'll stay. That will be the meaning of the word I am leaving it.
No, your lordship, since your lordship is dictated.
We'll come back at 2 o'clock.
Lord.
Without giving an indication that I am hungry. Yeah, it will take some time because maybe it will go into a number of issues. On the issue as to whether the respondent Montfort High School, being a minority institution under Article 31 of the Constitution of India, would be excluded from the definition of non-government educational institution, comma, in order to bring it within the purview of the Act of 2006, comma. We have taken note of the where is that certificate that it's
In my affidavit in opposition or
no, which page it will be?
page 54. Serial.
54. We had taken note of the certificate issued by the National Commission for Minority Educational Institutions, Government of India, wherein it is certified that Montfort School at Sabua in the Dibrugarh district of Assam is an institution covered under Section 2G of the National Commission for Minority Education Institutions Act 2004. Comma, meaning thereby that it is a minority educational institution, and as such would be entitled to, and as such would be covered by the provisions of Article 31 of the Constitution of India. As the respondent Montfort High School is a minority institution under Article 31 of the Constitution of India, we take note of the definition of non-governmental education institutions in the Act of 2006 at Section 215, which is extracted as below. A reading of the definition of non-government education institution under Section 215 of the Act of 2006 makes it discernible that there is an exception as regards schools established and maintained by the minorities under Article 31 of the Constitution and imparting education at primary, middle, secondary, and higher secondary level without receiving any grants in aid from the state government to be excluded from the definition of non-government educational institutions. Apart from the respondent Montfort High School being a minority institution under Article 31, we also take note of the statement of the Learned Council for the respondent Montfort High School that the school does not receive any grants in aid from the government of Assam for its functioning. As the institution is a minority institution under Article 31 and it does not receive any grants in aid from the state government for its functions, comma, we agree that the respondent Montfort High School is not a non-government education institution under the Act of 2006. As the respondent Montfort High School is not a non-government education institution as defined in Section 215 of the Act of 2006, we are also of the view that the said school would not be subjected to the provisions of the Act of 2006. As the respondent Montfort High School would not be subjected to the provisions of the Act of 2006, it would also be acceptable that the procedure provided in Section 15 of the Act of the procedure prescribed.
The procedure provided in Section
15 of the Act of 2006 with regard to to any appointment or any other conditions of service in respect of the persons appointed in Montfort High School would also কি করলো?
The response of high school not be subject to the provisions of the Act of 2006, it would also be acceptable to the provider under section 15 of the Act of 2006 with regard to any appointment, any other conditions of service in respect to the person appointed in Montfort High School
would also not be governed by section 15 of the Act of 2006. It being so, the contention of the petitioners that the provisions of section 15 of the Act of 2006 had been violated while the impugned communication dated 4/4/2022 was issued discontinuing the service of the petitioner would also be untenable in law. Accordingly, we examine the other contention of the petitioner that irrespective of the applicability of the provisions of Act of 2006, there is also a requirement to follow the procedure of natural justice before discontinuing the service of a teacher. Full stop. But in doing so, we also take note of the submission of Mr. E. Dhor, Land Counsel for the respondent Montfort High School, that as well as that of Mr. B. Kaushik, Land Counsel for the Secondary Education Department, that a writ petition under Article 226 of the Constitution of India would not be maintainable in respect of the impugned communication discontinuing the service of the petitioner. To appreciate the rival contentions on the maintainability of a writ petition under Article 226 against the respondent Montfort High School, we take note of the submission of Mr. S. Borthakur, Land Counsel for the petitioner, who relies upon the provisions laid down by the Honorable Supreme Court in Andi Mukta Sadguru Sri Muktaji Vanda Swami Suvarna Jayanti Mahotsav Smarak Trust and others. Versus V.R. Rodani and others, reported in 1989 to STC 691. We take note of this submission. Mr. S. Borthakur, Land Counsel for the petitioner, relies upon the provisions in paragraph 20 and 22 of the said pronouncement to substantiate that, as the Montfort High School is discharging the functions of providing education, comma, it is discharging a public function, and therefore, whether or not it is an instrumentality of the state under Article 12 of the Constitution, comma, but by virtue of the nature of functions discharged of providing education, comma, which is a public duty, comma, the respondent Montfort High School would be within the meaning of one inverted comma, any person or authority under Article 226 of the Constitution of India. It is the submission of Mr. S. Borthakur, learned counsel for the petitioner, that as held by the Honorable Supreme Court in paragraph 20 of the judgment rendered in Andi Mukta Supra, comma, the restricted meaning of an instrumentality of state under Article 12 would be in respect of petitions under Article 32 of the Constitution of India, and such restriction would and such restricted interpretation would not be applicable in respect of a petition under Article 226, wherein the expression one in any person or authority is given a much wider meaning, and therefore, as the respondent, Montfort High School is also discharging a public duty, therefore, a writ under Article 226 would be maintainable against such respondent. The provisions of the Honorable Supreme Court in paragraph 20 and 22 of Andi Mukta is extracted as below. In appreciating the contention raised by Mr. S. Borthakur, we also take note of the provisions laid down by the Honorable Supreme Court in its judgment in St. Mary's Education Society and another versus Rajendra Prasad Bhargava and others, reported in 2023 for SCC 498. We specifically take note that the judgment rendered by the Honorable Supreme Court in Andi Mukta Supra had been considered in paragraphs in paragraph
38 or
23, 38, 68, 'full stop. In paragraphs paragraph 23, the reference to the pronouncement in Andi Mukta Supra is in respect of a submission made, a written submission made by the respondents before the Honorable Supreme Court. To take note of the propositions laid down therein. And in paragraph 38, the Honorable Supreme Court takes note that the proposition in Andi Mukta Supra was also taken into consideration in KK Saxena versus International Commission on Irrigation and Drainage, reported in 2015 for SCC 679. In paragraphs 68 of its pronouncement in St. Mary's Education Society Supra, Honorable Supreme Court also refers to the judgment rendered in Ramakrishna Mission versus Kunia, reported in 2019 16 SCC 303, wherein in paragraph 25 thereof, one of the judgments relied upon by the petitioner in Ramesh Aluwalia versus State of Punjab and others, reported in 2012 12 SCC 331, was also taken note of. In paragraph 70, the Honorable Supreme Court also takes note of a full bench judgment rendered by the High Court of Allahabad, wherein in paragraph 18 thereof, it is provided that there is a thin line between public functions and private functions discharged by a person or a private body stroke authority, and a writ petition would be maintainable only after determining the nature of the duty to be enforced by the body or authority, rather than identifying the authority against whom it is sought. Para 18 of the pronouncement of the full bench of High Court of Allahabad in para is extracted as below. In paragraph 74, the Honorable Supreme Court also takes note of the proposition laid down in Ramakrishna Mission Supra in para 34, wherein it is provided that contracts of a purely private nature would not be subject to writ jurisdiction merely by reason of the fact that they are structured by statutory provisions. And the only exception arises in a situation where the contract of service is governed or regulated by a statutory provision. Having taken note of the provisions, some of which are indicated as above, the Supreme Court in para 75 of its pronouncement in St. Mary's Education Society Supra had summed up the final conclusion, which are as extracted. In paragraph 75(1) of its pronouncement, the Honorable Supreme Court provided that an application for under Article 226 of the Constitution of India is maintainable against a person or a body discharging public duties or functions. Full stop. But at the same time, it is circumscribed to an extent that for ascertaining the discharge of public function, comma, it must be established that the body or the person was seeking to achieve the same for collective benefit of the public or a section of it, and the authority to do so must be accepted by the public. From the proposition of the Honorable Supreme Court as provided in paragraph 75.1, we answered the question framed for an adjudication in we answered the question frame as to whether a writ petition would be maintainable against a respondent Montfort High School, and accordingly answer that the respondent Montfort High School having discharging a public duty or function, a writ petition otherwise would be maintainable. Full stop. But having said so, such maintainability would also be circumscribed to the extent that it must also be established that also be ascertained that for the discharge of the public function, it should also be established that for the discharge of the public function, the body or the person was seeking to achieve a collective benefit for the public or a section of it, and the authority to do so must be accepted by the public. To ascertain the same, we take note as to what issue is raised in this petition and what action of the respondent Montfort High School is being assailed. As noted, a communication dated 4/4/2022 is assailed in this writ petition, by which the service of the petitioner has been discontinued. To examine the aspect further, we also take note of the propositions laid down by the Honorable Supreme Court in paragraph 75.2 and 75.3 of its pronouncement in St. Mary's Education Society Supra. In paragraph 75.2, it is provided that even if it is assumed that an education institute is imparting public duty, the act complained of must have direct nexus with the discharge of public duty. And in paragraph 75.3, it is provided that it must be consequentially held that while a body may be discharging a public function or performing a public duty, and thus its actions becoming amenable to judicial review by a constitutional court, comma, its employees would not have the right to invoke the powers of the High Court under Article 226 in respect of matters relating to service where they are not governed or controlled by the statutory provisions. কি বলবো sentence টো? In the said paragraph, it had further been held that an educational institution may perform myriad functions touching various facets of public life and in the societal sphere. But while such of those functions would fall within the domain of a public function or public duty to be undisputedly open to challenge and scrutiny under Article 226 of the Constitution, but the actions or decisions taken solely within the confines of an ordinary contract of service, having no statutory force or backing, cannot be recognized as being amenable to challenge under Article 226 of the Constitution. And in the absence of service conditions being controlled or governed by a statutory provision, the matter would remain in the realm of an ordinary contract of service. In the instant case, it is noticed that the petitioner was appointed in the respondent Montfort High School pursuant to a contract between the parties, and the Montfort High School being not a non-government educational institution within the meaning of Section 215 of the Act of 2016, the service conditions of the petitioner pursuant to such contract arrangement would have to be accepted to be not covered by any statutory provision. It being so, a reading of the communication dated 4/4/2022, by which the services of the petitioner had been discontinued, makes it further discernible that it is an arrangement between the respondent Montfort High School and the petitioner for discontinuance of service because of the reasons stated therein, which appears to be more of internal matters between the respondent school and the petitioner, which definitely would be within the confines of an ordinary contract of service, having no statutory force or backing, nor recognized force or backing. Accordingly, the other proposition laid down in para 75(1) of the pronouncement of the Supreme Court in St. Mary's Education Supra, circumscribing the maintainability of a petition under Article 226. Read with the provisions in paragraph 75(2) and 75(3) of the said judgment, leaves the court to arrive at a conclusion that although the respondent Montfort High School may be subjected to a writ jurisdiction under Article 226, having, by virtue of being discharging public duties or public function. But in respect of the impugned communication dated 4/4/2022, by which the services of the petitioner was discontinued, being within the realm of ordinary contract of service, comma, a writ petition against the said communication of 4/2/2022 would not be maintainable under Article 226. In view of such conclusion, the writ petition stands dismissed. The interim order passed earlier stands vacated. However, we are clarifying that we have not expressed any view on the legality or acceptability of the communication dated 4/4/2023, by which the services of the petitioner had been discontinued, nor in respect of any of the reasons stated therein. The writ petition is held to be not maintainable on a technical aspect of the maintainability of an application under Article 26 in respect of an ordinary contract of service between the respondent, Montfort High School, and the petitioner. As the writ petition had been dismissed on a technical aspect as indicated above, comma, liberty remains with the petitioner to approach any other appropriate forum if so advised, and the dismissal of this writ petition shall not be construed to be also a dismissal on the merit of the claim of the petitioner against the communication dated 4/4/2022.
If I am permitted, I'm just relying on another paragraph of this judgment, paragraph 47. There is another judgment of Supreme Court has been relied on. Paragraph 47.
Antiwala.
Something. Make something
Hmm.
clear.
Doesn't matter. No, this one is not a state within the Article 12 is okay, because Article 12 is in Part 3 of the Constitution. Article 31 is also in Part 3. So when you raise the issue of minority institution, it's not an instrumentality under Article 12. But Andi Mukta had given a broader meaning that if it is a writ petition under Article 32, the relevance of Article 12 comes in. But if it is a 226 writ petition, any other authority had been given an expanded meaning that it would be included even if it is a minority institution, provided it is discharging public function. Had it been for other cause relatable to a public function, maybe you would have entertained a writ petition, although it's a minority.
Just
By virtue of 226, not by virtue of Article 12.
And
Because
since
this one is-
Act came in 2004, and this judgment is rendered in 2011, and this Andi Mukta was rendered in 1989, while this act was.
But in St. Mary's, Supreme Court had
Yes,
taken note
this
of that.
is that- that's that.
In St. Mary's,
It is that.
Supreme Court had exclusively dealt with Andi Mukta
Yes.
on that proposition. And it comes to its conclusion in 75(1)
Exactly.
that if it is a discharging public function, it is maintainable. But subject matter.
Matter.
What is the issue? If it is a private dispute, contract of service, no writ.
No.
If it is something different, maybe against Montfort also, it will be maintainable.
Conclusions are conclusive.
Suppose somebody files a writ that Montfort is giving such kind of education which is detrimental to the public,
That
may
is
be
right.
maintainable.
Right.
There you can't take the plea because of this one now.
My lord, it WPC 3576 of 2022. Also been disposed.
That has also
Yeah.
been disposed.
Accordingly, the other writ petition WPC being also against an order of suspension of a
Yes.
similar nature pursuant to ordinary contract of service. The writ petition stands dismissed.
Deeply obliged.
Obliged.
Time being 22 to 25.
Madam, who's just Mr. Dhar, Bhathakur gone. We are conscious of the aspect that because of our interim order, the petitioner was required to remain in service, and for the intervening period was paid, was then Montfort is required to pay the salary and allowances. As the interference is more on a technical ground, on a maintainability of writ petition under Article 26 and not on the issue of merit, we provide that the respondent Montfort shall not initiate any proceeding for recovery of the salary paid during this intervening period when the interim order was in force.
Obliged.
Obliged. Deeply obliged.
From where will they give back the money? From now onwards, don't pay. But whatever is paid, don't ask them to give it back now.
22 to
Yes, Mr. M.H. Loskor.
My lord, here in this petition, my lord, item 22, we filed an affidavit. There is one issue, my lord, which involves in all this repetition with regard to the inclusion of Hindi as a language in section 3111 of the 2017 Provincialization Act. In that, my lord, we have filed a detailed affidavit in one repetition. My lord, if your lordship takes that repetition, my lord, that
On the
issue-
prayer of Mr. B. Kaushik, Land Counsel for the respondents in the Secondary Education
Right.
Department,
element.
elementary list along with WBC so and so,
WBC
wherein
351
an affidavit has been filed, wherein also a similar issue has been raised, and the stand taken in the affidavit would cover all the
All the-
petitions.
Okay,
List
so
on-
affidavit may be furnished. Yeah,
List.
I'll
Definitely.
WBC 351 2020.
List on when,
351.
when do you want?
Anything.
For us, it is not any day. You take a date whenever you want,
Next week.
as an available whenever you want. Prabhasan ji, yeah.